I like to always start these meetings, these webinars that we've been running since the days of COVID, with a brief introduction and market updates so that you have an idea of kind of where we are as a market. A lot of this is related to Luton, but if you have properties in other regions, some of the things will be similar, and I can always delve into other areas if there's anything in the chat that you might want me to address. So again, Vanessa from VA Properties. I'm the owner and director of VA. Started VA right here in my home about 13, 14 years ago, and it's grown to a team of healthy property professionals who work together with me. We don't just rent properties for landlords, but we also manage, we sell, and more these days, I would say in the last, probably in the last couple of years, we've launched a service called VA Landlord Rescue, which is quite apt for tonight because that service was launched, or it was born out of landlords who were needing what we called a form of rescuing from tenancy situations that they were facing. So things like reviewing landlords' contracts, serving Section 21s for landlords to ensure that they're being done properly, helping landlords manage tenants in serious rent arrears. So anything that kind of falls under a rescue type situation, VA Landlord Rescue was born out of, and we're seeing more and more of that in the last 6 months. So just to kick off this evening, I'd like to start with a brief market overview of what's happening in the Luton rental market, because we cover predominantly the Luton area. From a landlord's point of view, this is tonight, not so much from a purchase or a seller's point of view. So from a Luton point of view, the market in 2026 at the moment, we're seeing the rents, they are still steadily rising. I've got some figures here from the ONS. So we're seeing a rise of about 3.5 to 3.9% year on year in terms of how our rents are rising in Luton. But one thing we've noticed as a team, the rents, yes, the rents are rising, but they're not rising as fast and as high as they were, say, 2-3 years ago. So we have seen what we call a slight cooling down on the edge of the very high rents, and that's due to a number of reasons which I'll talk through shortly. So where we've had landlords in the recent months, certainly in the last 6 to 9 months, come forward with new properties to let or relets, and their expectations are these very, very, very high rents. We've found that quite challenging in the last 6 to 9 months. We're seeing an average rental figure across Luton of just over £1,200 at the moment. To give you a rough idea of the approximate rents that we're seeing across the different number of bedrooms in our area, you can see there on the presentation, 1 beds are looking from around 900 up to about 1,100 on a 2-bed, 3 beds in the region of 1,400, and from 4 bedrooms upwards, you're looking at 1,700, 1,900. These are very approximate figures. It can be higher, a little bit lower, all depending on the exact location of your property and, of course, your property's condition and presentation. But those are the current approximate rental levels that we're seeing across the Luton market in the last probably 6 to 12 months. In terms of supply and demand, there is still a very, very strong demand for properties from tenants, despite despite the high rents and what we call the affordability challenges, because of course, where the rents have risen so much in the recent years, we're finding that a lot of tenants are struggling to meet the affordability. And what I mean by affordability, in case you're not sure of that terminology, is for a tenant to qualify for a property, they have to show an income, a household income of at least 2.5 times the rent. We've sort of etched that up a little bit at VA to look for as close to 3 times the rent as a minimum as possible, because obviously the stronger the earning power into that household, what the law of averages says is then your rent should be more secure to be paid. So we are seeing affordability challenges with tenants, but that said, the demand is still there. From commuters, from families, particularly international families. There's been a lot of international families come through in the last few years from different parts of the world, from Africa, from Asia. We're seeing a lot of that. We have seen a lot of our European tenants, mind you, over the years they've left for various reasons. So, you know, the market waves keep changing, but like I said, the demand is still high. Landlords, from a landlord point of view, we are seeing a lot of landlords exit the property market for various reasons. Yes, a lot of it is to do with landlords not wanting to take on this new wave of legislation. Maybe they've had their properties many years, and it's time for them to look at other things in their life. So we're seeing a lot of exit from landlords selling, but we're also seeing landlords talk about taxation. A lot of landlords are not happy with the taxation rules that have come through in the recent years. So landlords are also releasing properties based on the numbers, really. So there's a lot of that transition going on in the market at the moment. But it's still a good market, certainly in Luton, and it's still very competitive, particularly for 2 and 3 beds in the Luton area. Just to touch back on the point I mentioned a few minutes ago about affordability pressure. So another pressure that's coming on the tenant market, and this is not just Luton, this will be UK wide, particularly in the south, is the difference between what the local housing authorities will pay in terms of the government rents and the market rents. We're finding that the gap where the rents have risen so high and keep rising to a degree, the gap between the LHA, which is the local housing allowance, if somebody is entitled to any form of universal credit or housing benefit, the difference between what they will receive and what the market rent, the gap is widening. And of course, the bigger the gap, the more at risk a tenant could be in terms of falling into arrears, because it's a lot more money for them to make up. So landlords, we have to be very conscious of that, particularly if we have tenants who are in receipt of any universal credit or benefit or partial benefit, because that gap is widening and making it a lot more challenging for the tenants to afford. But on a very positive note, I don't want this to sound like a negative on landlords, because the buy-to-let space is still a great space despite the challenges that we face. Luton's rents still remain a lot lower in comparison to other areas in the east of England, which makes it a very affordable, commutable town. Hence, we see a lot of commute tenants coming through, which is a positive for our buy-to-let market. So with that, landlords' yields are still strong because rents are lower, tenants are coming in, they're paying in higher. It does still produce good yields for landlords. But yes, as we move through this year, we will see a lot more compliance burden on landlords, which will kind of change the face, of how we rent and market our properties. Just as a last couple of points, I think what this means for the buy-to-let landlord space this year and next year is that landlords will still see a steady growth in their rental income and their yields with a good, strong demand from tenants, but there will be a lot more what I'm calling scrutiny on tenants, because with the changes coming through that we'll discuss very shortly, I think when we're letting and reletting, the tenant referencing criteria is tough as it is, but I think it's going to get tougher and tighter because obviously landlords are going to be quite conscious of what's ahead. So scrutiny will be a lot tighter on tenants due to the regulation. And I feel what I'm terming, your property will have to be like almost graded like an EPC. Where at the moment we have obviously the energy performance is grades from A to G, and I think properties are going to have to move into that sort of standard where you're going to have to present as a landlord a property that is classed almost as an A grade, a B grade, a C grade. And what I mean by that is in terms of what it looks like, how it functions, how clean it is, have you done all your repairs? Your properties will now we're going to have to step up our standards, and that's part of the reason the Renters' Rights Act exists. And I think it's a positive reason because we are here to give out homes and we want to give out good, standard and decent homes. So I thought us as landlords, we're going to have to look at our properties almost like an entire EPC in itself and ensure that we're giving out ABC kind of graded properties so that way we stay ahead of the market. From a tenant's point of view, I think for them, on the positive, the rent increases will be more modest to what they have been in the last 3 years. Obviously, they're going to have more protection with the Renters' Rights Act coming through, and they will have to compete a lot harder for good homes. So, it's going to swing in roundabouts, and I think us as landlords, if we set ourselves up correctly, hence we're here tonight to learn and hear more, we will be in a good space, but we just have to be able to navigate the changes ahead. As a last point before I introduce our speaker, if anything of what I said either ticked any boxes with you or you're not sure about, we've got a free renters' rights risk assessment. If you want to take a picture or connect to the link using the QR code on the screen, that will take you to a very quick landlord's health check questionnaire, where it will then, once you fill out a few questions, it's literally about 30 seconds, it will give you a rating and a score, and it will tell you how healthy your tenancy is as a landlord, because these are the points that you will need to be looking into if you score low or if there are some high risks about your tenancy, because these are the things that you will probably need to address as a landlord, particularly as we move into the 1st of May. So feel free to take a picture or a screenshot, or just tap the code, the link from the QR code, because I think you'll find that really useful to see how you score on that renters' right risk assessment. And that ends the brief market update for this evening. So if you bear with me one moment, I'm just going to stop sharing my screen so I can then move to bringing in our presenter for tonight. Okay. Fabulous. So what I'd like to move on to next is to bring in my guest speaker. This lady was, if you were here, we ran a webinar, I believe it was mid-end of October last year, where I brought our special guest speaker for tonight. I brought her onto the platform because if anybody knows anything about tenancy legals, is this lady right here. So and she was received so well. A lot of landlords who weren't even able to make the webinar that evening in October, they watched the recording, and I must truthfully, hand on heart, say it's probably the one that's received the most positive feedback, because what Dawn brought to the webinar was a lot of clarity. She simplified, which I think is really important as landlords. Otherwise, a lot of this legislation can just go way over our head. But she really simplified what was ahead, and that was really taken on board and appreciated by landlords. So we had to bring her back as we're in the run up to the go live. So permit me to read Dawn Bennett's professional profile so you have a real understanding of who she is and why she's going to be sitting with us this evening and giving us her time to break down as much as she can about the Renters' Rights Act. So Dawn is a trusted expert in the lettings legislation and operational compliance, helping landlords stay protected, profitable, and fully up to date with the ever-changing legal landscape of property letting. With over 20 years of hands-on experience, Dawn has worked across every level of the lettings industry, from frontline negotiator to branch manager to now leading large-scale tenancy management operations for landlords and agents across the UK. Her deep knowledge of the lettings law, combined with real-world experience, means she offers practical, clear guidance that keeps landlords safe and their investments secure. Dawn currently leads a full tenancy and compliance management service, overseeing thousands of tenancies and ensuring legal best practice from move in to move out. Dawn also delivers landlord-focused compliance training, advisory support, and legal update sessions designed to give landlords peace of mind and confidence in their responsibilities. If you're a landlord and you're looking to stay compliant, avoid costly mistakes, and make sure your property is managed to the highest legal standard, Dawn is an expert that you need in your corner. So without further delay, I'd like to introduce Dawn Bennett, who I call my tenancy legal queen. Thank you, Dawn, for joining us this evening. We are so looking forward to hearing from you, to conversating with you. We're going to keep this as interactive as possible, as I said. So please, landlords, please drop, if anything that Dawn says springs a question to your mind, drop it in the chat so that I can pick that up, because I'll be also conversating with Dawn as she goes through the presentation, but she's here to really help us understand and navigate the changes ahead. So Dawn, thank you very much, and over to you.
Thank you very much, and thanks for having me back. What a privilege to be called again, and this time so much closer to the actual implementation of the Renters' Rights Bill. So today we're going to do things a little differently. We're going to go into presentations mode, so just bear with me one moment while I find my slides. Make sure I am sharing effectively. Just one moment. Yep. Is it on slideshow, Vanessa?
We've got your slides. You just need to make them large for us, and we're good.
Okay, just one moment. See, this is where I always go wrong. Slideshow. There we go. From the beginning. So can we see that now, guys? Can everybody see what I can see?
Yeah.
Okay. Yeah. Wonderful. So the Renters' Rights Act 2026, now this is something that I've been talking about probably for the last 3 to 4 years. It has been in the government's mind for around 5 to 6 years, but there's been a few things that have happened over the course of the last 6 years, government changes, COVID, and a whole other array of things. And eventually now we are in a position where we know when this is coming into force, and it is going to be in force in 2026. So I'm here today to talk to you and answer any questions that you may have about the upcoming bits of legislation and all of the key changes that we will be all facing, both us as letting agents and you, more importantly, as landlords. So firstly, I wanted to start by talking about the introduction and the timeline of the Renters' Rights Bill, because what the government have decided to do is they have decided to break it down into 3 phases. As Vanessa alluded to earlier, this is the biggest change to the private rented sector in 37 years. The biggest change. Am I repeated? There we go.
Yeah.
That's better. Okay. Can you still hear me, Vanessa? Yeah?
Yes.
Yeah. So the biggest change that happened 37 years ago was a positive change with the introduction of the Housing Act in 15th of January 1989. Unfortunately, this piece of legislation is not so positive, and there are many elements that landlords will be concerned and worried about. But overall, as Vanessa said earlier, I think we need to just embrace the change. It is happening, and the private rented sector will still be a great space for landlords to be. We're based in the Midlands, and we're experiencing landlords exiting the market. But on the positive side, we're also seeing new landlords coming into the market. So whilst the older people that have been around for some time may have bought in the early noughties, they may now be looking to exit. But there's a lot of new landlords and new blood, particularly buying in creative ways through companies and so forth, that are still coming into the market. So for me, I believe that the private rented sector is here to stay. It's really important. We just need to get used to the new changes. So phase 1 is what we're going to talk about today, which brings the majority of changes to landlords and agents and will be coming into force on the 1st of May 2026. So we literally are 3 weeks away from this implementation date. It's coming in on a Friday, and as of that date, everything that we talk about tonight will change. And for the first time in a very, very long time, if ever, the introduction of phase 1 is actually retrospective. And what that therefore means is that it will affect not only every new tenancy from the 1st of May, but every existing tenancy that is already in force. Now, phase 2, I'm not going to talk to you much about that this evening, but phase 2 is due late 2026, early 2027. And will be bringing further changes our way. In short, in phase 2, that is when we will be having introduction of the landlord property portal, where all landlords must be registered along with their properties, and also a redress scheme for every landlord. Phase 3 is way, way, way in the future. It depends where you get your research from. I've put 2030 onwards, but in some of the research that I've looked at, it could be as late as 2034. So we're a few years away from that. So let's just start by focusing on what is changing as of the 1st of May, so in 3 weeks' time. Stronger authority enforcement actually has already came into force, and that came into force on the 27th of December. Periodic tenancies, abolishment of Section 21. We're going to look at today existing Section 21s and also the transition period, because we do still have a very small window where the existing notices can be used. And I'm going to talk to you a little bit about that. I'm going to talk to you about the introduction of new grounds and how you will be able to gain possession in the new world and what that looks like. Rent in advance and the restrictions that this act will place on us. Rent increases and the rules that have changed around that. Rental discrimination, rental bidding, and rent repayment orders are the fundamental key changes that the Renters' Rights Bill is bringing our way. And I'm going to cover each one as a subject. As Vanessa said, please do feel free to ask any questions. Vanessa, if at any time you want to interrupt me and ask a question, please do so.
Will do.
So first and foremost, the thing that's already happened is stronger local authority enforcement and powers. And it's really important to note here, because we're talking to you as an agent, but also this applies to both agents and self-managing landlords. So as of the date, the 27th of December 2025, councils now have stronger enforcement powers to do many different things. Now, councils already have powers to issue improvement notices and to prohibit use of property and to also issue financial penalties. That has been enforced for a while. But what has really fundamentally changed with this section of the legislation is two things. Firstly, the councils now actually have a legal duty to enforce. It's not just if you are aware, they have a duty to be seeking landlords and agents that are operating in a manner that is unlawful and take enforcement action against either the landlord or the agent. So I know I work with a lot of letting agents up and down the UK, and multiple different areas have confirmed the same as what's happening in my local area, whereby councils are actually investing in recruitment for this purpose. Because one of the things that we need to bear in mind is that when an enforcement notice or a fine is levied from the council to a landlord or an agent, that money actually goes into the pot of the council. So they now have a financial benefit to enforce as well as a legal duty. Now, two of the things that I want us all to be aware of, for us as letting agents, the council can walk into our office at any given time without notice and make a request for the tenancy file under section 114. We need to provide that documentation at request, and failure to do so can result in penalties. Now, the same exact requirement applies to those that are self-managing landlords. So whilst you may not have an office, you will have a place of residence, an address that will be listed on the tenancy agreement, and so forth. The councils can enforce the same power on you as the landlord, and you too must comply as we must as a letting agent. So one of the things that I'm really saying to let-only landlords, self-managing landlords at the moment, is your documentation and record keeping in order? Because as letting agents, we're operating a business, and therefore we have CRMs, document storage, all sorts of processes and procedures in place because we're operating a business. But many self-managing landlords don't have the same setup that we do because there's not really a need to. But there will be a need to moving forward. Files, documents, and record keeping about everything is going to be critical. And then finally, the local authority can also enter a rented property within 24 hours notice or via the power of a warrant. So in a nutshell, this has been in force now for just over 3 months. The councils have greater powers. They have a duty to enforce, and we all need to be very mindful of this to make sure that we have everything that we need to in order. Now, one of the big changes that I think the Renters' Rights Act is bringing our way is periodic tenancies. And the truth be told, they have brought this act into force to try and make life for tenants easier. But I would say in about 95% of cases, tenants don't like the fact that they're no longer going to have fixed term security or security of tenure, as I would call it, anymore. So it's a bizarre decision that's made, but it is one that has been made, and it is one that is coming into force, and one of the big changes that we are going to have to become used to. So let's talk about what this means. So from the 1st of May, all tenancies, so that is existing tenancies and any new tenancies that are either assured and or assured short-hold tenancies, will fall under the Renters' Rights Act, and therefore they will immediately become periodic. Even if you did a 12-month tenancy today on the 9th of April, on the 1st of May, that would become periodic and it would automatically convert. Now, all new tenancies from this date that are created either by conversion or by a new tenancy now have a new name, and the new name is APT, which is Assured Periodic Tenancies. So as I say, all existing tenancies that fall under assured or a short-hold tenancies will automatically convert come the 1st. Now, what is important to note is if you have any tenancies that fall outside of either of those categories, so you may have a company let tenancy, you may let to a trust, you may be letting on a license. All of these fall outside of the Renters' Rights Act, and they will not be included in any of what we're talking about today. They will continue as a non-Housing Act tenancy in the same manner that they have been for all of this time. Now, there is some work that we need to do within the period of the 1st of May and the 31st of May to ensure that we comply with the conversion. Now, there's two things to note here. Firstly, if you fail to do this, it doesn't mean that the contract has not converted. It will still have converted to an APT. But what it does actually mean is if you fail to do this, you could be leaving yourself open to quite a large fine. So from the 1st of May, every tenancy agreement will be required to have written statement, which is prescribed information, basically. It's a written statement with prescribed info. And the likelihood is, as of the 1st of May, every new tenancy that we do will have that embodied in the tenancy agreement. So there won't be the need for a requirement of an additional document. But for any existing tenancies that will convert on the 1st of May, landlords or their agents must serve on the tenant the government leaflet. It's an information sheet that has been created by the government, and this must be served on every named tenant. Okay, it can be served either by post or via email, but one of the important things to note is that when providing it by email, it must be done as a PDF document, not as a link to the government website. Now, I know many people that have started to serve this document already. And if you were to do your research right now, there's nothing in the law or the legislation that says you can't do that. I've made a decision on all of the properties that we may manage that we are going to do it in between the 1st of May and the 31st of May, in case, in typical government style, they make some late amendments and you're going to have to reserve. So for me, that's when we're going to do it, and the government leaflet must be served between that period of time.
Dawn?
Yes, Vanessa?
So can I just ask, in case a few landlords, you mentioned something about serving that prescribed information on every named tenant. So if a tenancy agreement has 4 named tenants all in the same household family, each one of those tenants need to receive it individually. You cannot just send one document to the household. It has to be served on each individual tenant. So you would either post 4 addressed individually, or you would email 4 to 4 different email addresses. And be very careful about the email addresses, because many couples, particularly older people, they share email addresses. And one of the concerns for me, and you have to remember, this is new legislation, so we can only read the legislation as it's written, and things will become more apparent as we move forward and cases start to get heard in court and judicial law is created. For me at the moment, I'm trying to take a belt and braces approach, and I would insist that if somebody is using a shared email address, that I would send one via email, one via post, because we don't want to get caught out on technicalities. And is there any requirement, as far as we know at the moment, to hold any proof that we have sent that information?
Absolutely. The one thing I would say with regards to proof is it's one of the biggest things that we're going to need now moving forward for everything that we do. Evidence, evidence, evidence. So yes, there is absolutely a requirement. And there's talk about whether or not, if your tenancy agreement allows service via email, if it doesn't, maybe you should serve it by post. But again, it's very unclear, because when you read the legislation as it's drafted, the clear information about the government leaflet does say that it can be provided by email or post. So it depends how belt and braces you want to be. But the majority of tenancy agreements nowadays do allow for service by email.
Okay, thank you, Dawn.
No problem. This is really important because the government leaflet will apply to most tenancies and is pretty standard in terms of what we need to serve. But if there is a tenancy that you are managing or you are part of whereby there is not a written agreement available, and people might think, oh, this is not possible, but I have found multiple tenancies that we manage that don't have a written agreement for a variety of different reasons. We may have taken them over mid tenancy. There was no need to draw up a new agreement. A different type of document must then be served, and this is called the official written statement, which is a much more detailed document that will need to be completed and filled in and issued to the tenant. That only needs to be done where a written agreement does not exist currently. So that's the work we're going to have to do in the first month of implementation. Now, because we've gone periodic, we obviously need some rules surrounding what notice tenants need to give us. So I just want to highlight what the new notice rules are from a tenant's point of view. So they now legally have to give you 2 months notice, okay? All tenants need to now give 2 months notice, and the notice must be in writing. You can decline a verbal notice. It must be in writing in order for it to be valid. It also must be in line with a rental period. So if the tenancy started on the 10th of the month, the tenancy will end on the 9th of a month, with the full 2 months notice that needs to be provided. Now, as a landlord or an agent, you cannot dictate the format that writing, the notice in writing is provided. Now, normally, in old layman's terms, it would state in the tenancy agreement how they provide the notice, normally by post or email. But now we're not able to dictate that format as long as it meets the criteria. It could be an email, a text, or a letter, as long as it meets the requirements of the notice period. Now, if a landlord wants to, they can, of course, release a tenant earlier if they wish to, and agree a shorter notice period. And one of the key things here that I find really interesting is it states that the tenant cannot stay if they change their mind without landlord consent. Now, one of the questions that I'm asked a lot of the time, so what happens then if the landlord doesn't consent and wants the property back following receipt of notice from tenant, and the tenant then doesn't leave? Well, that isn't answered in the legislation, so we have to wait and see what that's going to look like. But ultimately, once they've served a valid notice, under the law, the tenancy should end and they should vacate the property. Now, again, this is a really another interesting fact that they've brought in, is that where you have joint tenancies, one tenant giving notice can and will end the tenancy for all. So if you've got, let's say, 3 people living in a property, one of the tenants give notice in the current world that we're in now, the other 2 could remain. We'd do a couple of changes of documentation and everybody's happy. What would happen under the new law is that the tenancy would actually end for all of them. And if some of them wanted to stay, we would have to renegotiate a whole new contract. So the existing contract would end, and everything will be dealt with in accordance with that manner, and a new contract would be created, so a whole new fresh APT contract. Now, the benefit to landlords on that is that if you are creating a new contract and the rent has increased, the market rent has increased, the rent can be renegotiated for the new contract, even though some of the tenants will have already been in there. And of course, one of the big changes is with the loss of Section 21 notice, landlords will only be able to serve notice of possession proceedings using the Section 8 notice, citing the new applicable ground. So for tenants, much easier. For landlords, a little bit more complex.
Dawn, before you go on this, so you've talked about the tenants having to give us 2 months notice.
Yeah.
So from a landlord's point of view, I believe we're still obligated to give our properties out on new tenancies for a minimum of a year. Is that true?
So yes, yes, kind of. I'm going to cover that in the next section, because ultimately the contract will be periodic for both parties. But with the new grounds that landlords are likely to use, which I'll cover in the next section after section 21, there is what's called a protected period. So I'll cover that shortly.
Okay.
Section 21 is quite simple now because we are only 21 days away. But the fact of the matter is you can still serve this until the 1st of May. But when I say the 1st of May, what I actually mean is it must be deemed served on the tenant by the 30th of April, because the 1st of May, the rules will change. So it needs to be in the hands of the tenant by this date. So we've got a very, very small window where if we are able to use a section 21 notice because all of the criteria is met, then we can still serve one. But that is running out now because we are only 21 days away. And after that date, it's gone, it's abolished. We will not be serving any more section 21 notices. We'll be in the new world, and we won't be serving another section 21 thereafter.
Dawn, there's a question here from a landlord regarding the section 21, and he says, if we serve a section 21 now, I think he means, do we still need to give them a copy of the Renters' Rights Bill?
Yeah, so again, it's when you read the legislation as it's written, it actually states that no, you don't need to serve the leaflet on the tenant. But in good old, in fact, I'll share it with you. In good old legislative writing, it's really hard to decipher. But basically what it says under the transitional period of the Act is that the amendments made by Chapter 1 of Part 1 do not apply in relation to the tenancy until the notice under Section 21 ceases to be valid. And accordingly, the tenancy remains an assured short-hold tenancy until then. So if you interpret that, it actually says, no, you shouldn't, because it will confuse matters. Because ultimately, the sheet that you're going to issue is going to tell them that it's converted to periodic, Section 21 is no longer available, blah, 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 blah. I just want some further clarification on that before we make ultimate decisions, because we didn't talk about the penalties for failure to serve that leaflet if and when required, but it's quite hefty. It's up to £7,000. So we want to make sure that we get it right. But if you read the legislation as it's written, it would suggest not.
Okay.
It's all still very new to all of us, and it's you know, sometimes interpretation, and particularly of legislation, it's quite hard to interpret what they mean, and you can end up going down the wrong routes and falling foul. So yeah, it's something to be very, very mindful of.
Okay, thanks, Dawn.
So guys, we're going to lose Section 21, so we need to talk about the fact that there will still be opportunity of gaining possession of your property, but that will only now be able to be done under a Section 8 notice. And there are some new grounds that have been introduced, quite a lot of new grounds, but the grounds that I want to talk to you about today are probably the most common grounds that landlords will use. Now, over the years that we've had Section 21 notice, there's normally 4 reasons why a landlord evicts a tenant under Section 21. They're either not paying the rent, the landlord wants to sell, the landlord wants to move back in, or the tenant's a pain in the backside and they just want rid. Now, in many of those cases, we will still be able to evict tenants, but the criteria and the rules surrounding those reasons are very different. So we just need to be mindful of that. So if a landlord wants to sell, they are able to use a new ground, which I believe is ground 1A. But a landlord must provide to the tenant a minimum of 4 months' notice. If the landlord or their family want to move back into the property, which is actually an existing ground, which is ground 1, the notice period for that is also 4 months notice. Now, we do have an antisocial behaviour mandatory ground. Mandatory means if able to be proven, the court has to give you possession. And mandatory grounds really are the grounds that we want to go to court on, because very few landlords are successful on discretionary grounds alone, because it's down to the decision of the judge. Judges tend to not like to give you possession on mandatory grounds, let alone discretionary grounds. So you need to be very mindful of that. But the antisocial behaviour mandatory ground is quite strict, and it requires things like crime reference numbers. It equates to domestic violence within the property where somebody's been prohibited from returning because of domestic violence and so forth. You can't use this ground just because your tenant's a pain in the backside, so to speak. And then one of the other grounds, which isn't a new ground but has had some quite significant changes, is the rent arrears ground that we use, which I'm going to cover after we've talked about the 2 grounds for landlord wants to sell and or the landlord or their family wants to move back in. Now, as we talked about just, Vanessa, with your question, both of these grounds offer tenants what's called a protected period. So these grounds cannot be served within the first 8 months of a tenancy, okay? So for example, if somebody was to move in on the 10th of May, you would serve the notice 8 months later to expire on the 9th of May the following year. They have to be given 12 months protected period. Now, a lot of landlords are asking me, what does that mean for our existing tenancies? When does that 12-month period start? And the easiest way for me to explain this to you is, whenever the last tenancy agreement was signed, so whether that be, if you moved somebody in of January this year, you will not be able to ask them to leave until January next year. So you would use the notice 8 months from January to expire January next year. But for those that may have done a tenancy renewal, that is the date that the tenant's protected period will start. So you may have started a tenancy in 2020, but if you have done a recent renewal of tenancy or a new contract of any sort for that tenant, then their 12-month protected period will start from the date that the contract was drawn up. Now, one of the other challenges with these 2 grounds is not only is there a protected period, but there is a restricted period when you take action and use one of these grounds, okay? So once a landlord has decided, I'm going to evict my tenant because I'm looking to sell, the restricted period means that the landlord cannot re-let that property for a period of 12 months after. Now, this is one of the things that concern me, because if a landlord genuinely wants to sell, puts the property on the market, and the property doesn't sell, they're not really going to want to leave it empty for 12 months. So I think what landlords should start to do is be a little bit more creative with their thought process, particularly if they want to sell. Could you sell with the tenant in? Is it a good investment opportunity? Because what you face by using this ground to carry out an eviction is you are then restricted for the following 12 months without being able to let it out if you are not successful at selling it. And one of the key factors here is, look at the penalty here, Vanessa. It's £40,000, and they've gone with the higher level penalty in this scenario, quite simply because they think that landlords are just going to use this as an excuse. They don't really want to sell, and therefore they'll just pretend that they want to sell and use the ground and evict the tenant. And truth be told, when we first started talking about renters' rights and we didn't know about the restricted period, that's what we as agents said. Well, the landlord could just pretend he wants to sell and then go and find a nicer tenant. But the penalties here are quite huge. So landlords need to be really, really mindful of this, because it can pose a problem. Any questions before I move on to the transitional arrangements for the existing Section 21s and 8s that are already out there, Vanessa?
Yeah, landlord is asking, is saying, can we give a tenant notice now, and then give them 3 months to move out, or is there a fixed period? So if a landlord wants to serve notice now, can they do that now, giving them a slightly longer notice period? I think that's what the question is.
Okay, well, what I will do now is when I cover this off with the transitional arrangements, it may make that a little bit more clearer, because there is some deadlines for us using existing notices, and those deadlines are becoming smaller and tighter the closer we're getting. So it would completely and utterly depend whether or not your Section 21 notice that you intend on using would fit into the timescales. We've got May, June, July. They may do. Let's have a look at the transitional arrangements, and hopefully that will become clear. If it doesn't, please revisit with the original question. Okay, so if you have served a Section 21 notice before the 1st of May, this still can be used, and it is valid for a period of up to 6 months from the date of service, okay? So those rules remain the same as they do now. A Section 21 notice is valid for up to 6 months from the date that it was served. However, the additional timescale now is or until the 31st of July 2026, whichever is sooner. So if you think about it, if a landlord was to serve a Section 21 today, 9th of April, and it was deemed served, the landlord would normally have until October to exercise the right to make a court application, because he's got 6 months from the date of service. That is now limited to a maximum period of the 31st of July. So if you have a Section 21 notice that is out there or is intending to be out there, you must make your court application. You must be in the court queue by the 31st of July 2026. If the court is not applied to in time, the Section 21 will immediately become invalid, and in order to get possession of the property, you have to use the new Section 8 and follow the standard possession route. So the timings have now become really important the closer that we're getting. So we need to be really mindful of that, and landlords need to act quickly if they are to rely on a transitional period notice. Does that make sense?
I think it does. I have an interesting question here from a landlord.
Okay.
Slightly different scenario. So the landlord says, the landlord rents, hi, I rent my properties through the local authority, so the council, meaning the local authorities took my properties for a 3-year lease. I do not have any connections with the tenant or decide on the tenant. I receive the rent from the local authority. I would like to know where I stand with the new legislation.
It will not apply to you as a landlord, because you are not renting your property as an assured tenancy or as an assured short-hold tenancy. You are leasing it on a lease to a company, so none of this applies to your tenancies. Now, where that may differ is if they are subletting it to tenants on an assured or an assured short-hold tenancy, then they may have obligations under the Renters' Rights Act to the occupiers that they are putting into the property. So for any landlords that are doing something like this, my recommendation would be to reach out to the local authority and ask them under what contract are they leasing the property to the occupiers, so that you have an understanding as to any potential risks that you may be facing should there be a delay in the council evicting said tenant in the property. But you as the landlord have no obligations under any of this.
Okay, I think that was a really good question, because I know for a fact that Luton Council here, they have moved away in the recent years from leasing. A lot of the contracts that they're pushing and they're doing with us as landlords and agents now is they're almost acting as an introducer for the tenant, and then the tenancy is between the landlord and the tenant. So I think landlords need to be really careful of that, because sometimes they word it a little bit clever to kind of, you know, get more landlords to come forward, because obviously they need the provision of homes, but they have moved away from doing lease agreements. A lot of the time you are now being locked in tenant to landlord. So we need to be aware of what type of contracts we're discussing with local authorities, because they're also becoming a bit slicker with how they present their different opportunities.
Absolutely. And from a landlord's perspective, like the landlord with that question, whilst they don't have to comply with anything, should they need to end that tenancy, they need to be aware of any risks that might delay them getting their property back due to the contract that's beneath them. So really, really good question. Okay, so Section 8, we've covered Section 21s then. So we've just covered that, and we know the transition period. The transition period for Section 8 is very, very similar. So if you have served a Section 8 notice on a tenant before the 1st of May using the old grounds, which are 2 months in arrears and a 14-day notice period, you have up to 12 months from the date that it was served, or until the 31st of July 2026 to act, whichever is the sooner again. Now, if you do not act on the notice by that point, you will have to serve a new Section 8 notice with the new rules, which the notice period is greater and the arrears amount is greater. So if you do have a Section 8 that's malingering out there with a tenant that's in arrears, make sure that you act on it as soon as possible. Now, Section 8s tend to come with a 12-month notice period from service to start court action. This only changes if the arrears are cleared. So if you serve a Section 8 notice on a tenant because they are in arrears, but they then pay that arrears and it becomes 0, you need to reserve a new one should they fall into arrears again. You can't rely on the old one. So guys, the deadline for notices served after the 1st of May, for notices that have been served prior to the 1st of May, is the 31st of July. We must all remember that date, because that's the date the court applications need to be in.
So Dawn, would you I know it's a case by case basis, but if you're a landlord and you have a tenant that has been with you for a while and they do slip in and out of arrears, but they do catch up, you know, and I think a lot of our landlords will have this sort of situation, you know, what would you say with what to do there? Because, you know, you're sort of on the fence, you know, do I release this now, or because the tenant always catches up, do I just let it go on?
I think it needs to be landlord's decision. But what I think landlords need to be aware of is knowledge is power, isn't it? So you need to be aware of, okay, if I continue to give the tenant a chance, what does it look like should I wish to evict them in the future? Well, we know we can't use Section 21, so we've lost that right. There is only probably 3 reasons why you will be able to evict them moving forward, and that is because you want to sell, because you want to move back in, or because your tenant is in arrears. But at this point, in order to use a mandatory rent arrears ground, they will have to owe you a minimum of 3 months. So truth be told, what I'm saying to landlords at the moment, if you are unsure, exercise your right to use it while you've still got it. And this is really unfortunate, because where landlords might be more flexible and have been more flexible in the past, government is pushing our hands now, because when we talk about rent arrears, which I'm going to talk about in a moment, that's one of my biggest concerns with the increase in rent in notice periods they've given. Because we were talking just today, Vanessa, that, you know, you could be waiting a year or so to get into court right now in certain areas of the UK, London being one of them. What's that going to look like in the new world? And does a landlord want to take that risk? Yeah. So if it was me, I'd really, really, really consider my options. And if you have a route to easier possession, I'd take it probably. And go again with another tenant. There's no guarantee that the next tenant that you get is going to be any better, but you know, the fact of the matter is your hands are tied.
Thanks, Dawn.
So where a notice is used for eviction, landlords need to be very, very mindful now that evidence is going to be fundamental in your possession claim. None of this we're just going to rock up and say that they're in arrears and that we've done what we need to do. You're going to have to turn up with, as you mentioned again earlier, Vanessa, a full bundle. Well, that bundle has just got greater because, for example, we already know deposit protection is one of the things we need to provide. It will be that the property is registered on the new property portal once it's in force. Safety certificates form part of that. The compliance pack now you will need to evidence, did you provide the written statement? Did you provide the leaflet? What communication have you had? When you're using a rent arrears ground in the new world, the court are expecting you to provide communication records with the tenant. What letters have you sent to the tenant? What conversations have you had with the tenant? Have you attempted to create payment plans with the tenant? All of this is now going to be required, and we're going to have to be really, really evidence driven when asking a judge to evict a tenant, basically. So if you're using, for example, the fact that you want to sell, there will be requirements for you to prove your intentions to sell. Maybe a signed contract through an estate agent, a listing on a property portal. We don't quite know what that looks like because I'm always thinking, well, that's just crazy because a seller can sign an agency agreement, as we well know, with an estate agent and then cancel it 14 days later, or withdraw the property from market. But landlords need to be very mindful that it is going to be very, very evidence-based moving forward for any sort of eviction to be granted in the court. So let's just talk about the rent arrears ground then, because this is the one for me where actually we've gone backwards. We've gone backwards to 1989, where a lot of you probably don't know, but I'm a legislative geek. But in 1989, we were able to evict a tenant if they were 3 months in arrears. And in 1997, the Housing Act reduced that from 3 months to 2 months, which was a blessing. Now in 2026, we're going backwards, and it's now the tenant needs to be in 3 months arrears again. So the amount of arrears a tenant needs to be in has increased by 1 month. Of course, that poses a greater risk to landlords, and you need to be very mindful of that. Not only have they increased the amount of arrears that they need to be in, but they've increased the notice period that a landlord needs to give to a tenant under a Section 8 notice from 14 days currently to 28 days in the new world. Now, if we look at facts here, in the current world, we're looking at 2.5 months, 2 months in arrears, 14-day notice period. Now we're looking at nearly 4, 3 months in arrears, 28-day notice period. So landlords are going to have an additional 1.5 months of arrears before they can even make that application to the court to get the process started. Now, as we discussed today, Vanessa, you know, court times are already terrible. And one of the things that was promised by the government before they brought in renters' rights was that they would sort out court reform, but they haven't, and we are not there yet, and we are nowhere near close to it. They are talking about digitization of the courts, but the reality is in the next 12 months, 24 months, we're going to have big queues in courts because Section 21 notices used to be dealt with through the post. They were an administrative function. Everything is now going to have to be heard in front of a judge, and therefore naturally wait times are going to be longer.
I mean, there's a landlord here, sorry to interrupt, Dawn, but there's a landlord here who says The courts in Luton are so far backlogged. My Section 21 with a Section 20 with a Section 8 is now nearly 2 years.
Wow.
Yeah.
Wow. And this is one of my biggest concerns. So the one thing that I'm really truly saying to landlords is that rent guarantee is now essential, not optional, if you want to protect your income. And just to put it into perspective, as Vanessa alluded to, we have our own letting agents in the Midlands and in the Northwest, and our rent guarantee provider have just very recently, in readiness for renters' rights, changed the cover time. So currently, landlords are covered for up to 15 months. So what that's indicating is you may be waiting up to 15 months to get your tenant out, right? They've actually made that indefinite moving forward because they don't know a timescale to put on it. So landlords, for me, if you are not in a position where you would be financially affected if you were without rent for 12 to 18 months, it could be longer. It's essential, not optional. And remember, rent guarantee doesn't just cover the rental element of it. It covers all of your legal costs, all of your representation in court. This to me now, a landlord that moves a tenant in or has a tenant in situ that doesn't optimize and take this rent guarantee is just crazy. It's really, really, really is essential. So that's it about the new grounds and the transition periods and so forth. Any other questions, Vanessa, before we move on to financial rules and rent controls?
The question here, or more of a statement here from a landlord, he's asking, how aware do we believe tenants are of these new regulations? I think as landlords, we're getting concerned about being screwed by immoral tenants taking advantage of these changes. So how much publicity, how much press has the government put behind this to really inform and educate tenants?
Well, in typical government style, they've put the process of educating the tenants on you as the landlord, because you have to provide the information sheet. So truth be told, if you've actually read the information sheet, they're not going to understand it. They're not going to understand what it means. It's very basic. It's very very basic is the word I'm going to use. Really, there should have been a lot more education, not necessarily from us as landlords or agents, but from the government and from the likes of people that have lobbied for all of these changes, like Shelter, that are tenant support, for tenants to become educated. I mean, ultimately, if we have a bad tenant, we are going to be able to evict them. But the question is, until this court digitisation and the court reform takes place, it's the landlords that are going to suffer with the length of time. But I think one of the things to bear in mind is that I attended a demo of something today, deposit replacement scheme. And whilst rent arrears is increasing, because as you said at the very beginning, Vanessa, there's been a lot of financial pressures at the moment. Fuel is now nearly at £2 per litre. There's a lot going on, cost of living and so forth. Rent arrears has increased, but it's only at 4%. So 4% of private rented sector tenants are in arrears, whereby before it was probably around 2%. So we've just got to protect ourselves as best that we possibly can as landlords. And for me, I know I'm an agent and I know you're an agent, Vanessa, but I do not shy away from the fact that I am saying to all of my self-managed landlords, any self-managed landlord that will listen to me, do you really want to face this new legislation if you don't know everything that you need to? Because the penalties, the financial risks of getting it wrong is just ludicrous. And I'm also really, really confident in saying to landlords, you must have rent guarantee unless you've got an endless pot of money that you're able to, sustain a tenant not paying rent for 12 to 18 months. We've got to change the way.
A landlord is asking, can you recommend a rent guarantee company and how much does it cost? I think on that one, I would say there's a number of, there's tons of suppliers out there. They generally all work to a core system, but some of them will have their own requirements cost-wise. Some will base on a fixed cost, some will base depending on your rent. So some will price in rental brackets. So a rent from 500 to 1,000 would cost X in the premium from 1,000 to 2,000. So it all depends, but so it's difficult to give you a figure. I mean, we do rent guarantees from 300 to 400 to 500 pounds for the annual premium. So it all depends usually on the provider that you're working with and the rent that you're working with. So it's not a very direct question that you can say it costs X, but what I can say is in comparison to what you could potentially risk and lose with a tenant not paying even just 1 or 2 months rent, it's nothing in comparison to that to protect yourself for the year. But the cost will vary depending on your category of rent and the supplier that you go with and your location.
And also another thing to note is that rent guarantee providers at the moment, if you think about it, right, they're quite nervous about these new laws because their risk is also growing, because the longer they can't evict a tenant, the more rent they're having to pay out. So truth be told, there are certain rent guarantee providers that won't assist self-managed landlords. They will only assist letting agents. So you really do need to do your research. If you're a self-managed landlord, you need to make sure, because there will be rules and criteria that you have to follow to make sure that that insurance is valid. But that being said, still please go out there and have a look, because it is invaluable. Okay, so what do we want to talk about financial controls? Well, they've also put a caveat in that rent in advance can no longer be taken any more than 1 month's rent in advance. Vanessa, I don't know about you in Luton, but here in the Midlands and in our Northwest office, we regularly have tenants that want to pay 6 months rent in advance, 12 months rent in advance, because they are new to the country, they failed referencing, they don't quite meet the criteria. Well, good old government have put a restriction on that as well, whereby it is a bit of a grey area, okay? What they are saying as standard is that you cannot take any more than 1 month's rent in advance. There is a very small caveat that I'm going to leave here, and what they said was, unless the tenant offers it. But this is a really grey area, because you will have to prove that the tenant made the offer, not that you insisted, not that you coerced, not that you indicated. It needs to be a free of choice offer. And therefore, as a letting agent in our area, we've decided that we're no longer going to take rent in advance, because the risk is too great of that being misinterpreted. And again, the penalties can be quite large. Now, that is quite straightforward in itself, but one of the things that's not quite straightforward, and what landlords also need to be aware of, is that rent cannot be requested to be paid, any amount of rent, not 1 month, not 6 months, whatever the case may be, until the tenancy agreement is signed and executed by both parties. So the landlord has to have signed, the tenant has to have signed, the contract needs to be live, and only then can you ask for the first month's rent. Now, why does this concern me? Well, firstly, you've now got a legally binding contract. So if the tenant doesn't pay the first month's rent, you still legally need to give them the key. You can, of course, have a holding deposit of 1 week's rent and the security deposit before you execute the tenancy. But legally, we are leaving ourselves open to having to hand keys over whereby the tenant has not paid the first month's rent. And as a letting agent and a landlord, we need to be very, very mindful and careful that we are not accepting that rent before the contract has been signed and executed. So, for example, if tenant decides to pay it early, we must return it until that contract is signed and executed. Now, once the first payment has been made, tenants can choose to pay early if they wish to. So if the rent is due on the 10th and they want to pay it on the 1st, that's fine. It can be held on account. If the tenant wants to pay 3 months rent in advance after that first month's rent, then they can. But any rent taken in advance must be returned to the tenant should they exercise their right to end the tenancy early. So if as a landlord, they've paid you 6 months rent on month 2 and then want to give notice and move out on month 4, you legally must return the rent in advance for the period that they are not there. So what this means for landlords is that, again, if you are not using a letting agent and you're doing this yourself, the whole process that you would follow or normally follow to sign up a tenant needs to be amended, as does ours as letting agents, in order to comply with this part of the legislation. Any questions there, Vee? That one normally drives landlords insane.
Yeah, I think what's going through my mind, just to see if I've got this right, and maybe there's a few other landlords feeling the same. So you're saying, Dawn, we can't accept the rent now until the tenancy has been executed, so signed by both parties, fine. And then we take the first month's rent in advance. But then are you saying that once that tenancy is live, if a tenant wants to pay more rent in advance, i.e. another 5 months, we can then accept it from day 2, day 3 of that tenancy?
Yes, as long as you have not enforced it.
No enforcement.
As long as you have not enforced it. Once the tenancy has been entered into, then yes, the tenant can pay as much rent as they want early. But it must be returned to them if they vacate.
Okay. That's an interesting one.
I mean, the biggest concern for me there is tenants getting wind of this fact that, forget the rent in advance in terms of the amount of rent, so 6 months, 12 months, ignore that for a moment. Just let's go down the normal world of 1 month rent in advance. At the moment, how we would operate is we would say to a tenant, you've been successful in this tenancy. Please make payment to us on this date of the security deposit and the first month's rent. At that point, we'll execute the contract and the deal will be done. We wouldn't execute that contract until we've got the money in our pocket, because that's protecting the landlord. But now we have to do it the alternative way around, where we have to make the contract legally binding and then hope they pay the rent. Because if they don't pay the rent, normally in the normal world now, we just wouldn't give them the keys.
Yeah.
But in the new world, we're going to have to, because they have a legally binding contract that they can enforce for us to allow them to move in. So something for landlords to be mindful of. I don't think overall it will happen, but we need to be mindful. Okay, rental bidding is also going to become forbidden. I don't think this is going to have a big impact on the market because the market has quietened and steadied. But basically what we're saying is landlords and agents cannot encourage or accept a rent higher than the advertised price. So if you're marketing your rent at £1,000, you cannot accept a rent above that figure. You can, of course, accept a rent below that figure, but you must not and cannot accept a rent higher than that figure. Now, what I think this will do is I think it will work in the opposite way that they hoped. And I think landlords will put it on at the highest possible amount that they can try and achieve. And therefore, that will just push rents up, because if they achieve it, then that's what the given market rent is going to become. So I think it's going to potentially push rents up again, because landlords are going to try and maximize what they can get in on the open market. And they potentially, if they've got a grace period of the property's not empty, they're going to try it at a higher rent. And why not? I would encourage my landlords to do that. But it is important to note that if we are caught foul of doing this, there is quite a hefty fine, £7,000. They're also saying that there's an additional fine of £7,000 for repeat offences. So, for example, if a landlord is fined once, £7,000, and then 1 year later is fined again for the same offence, the penalty could be £21,000, because you're going to get your £7,000 initial fine, your £7,000 second offence fine, and your £7,000 for the repeated offence element of it. So it is really important, landlords and agents, because we can be fined for doing this, stick to the law and the rules. Any questions, Vanessa, before I continue?
Not specifically on those. There's a few questions, but I think I'll come back to them so we can. Yeah.
No problem. Rent increases. This is another big one for me, probably bigger for me than actually Section 21 notice. And I think I said that to you back in October. Rent increases are becoming quite, not difficult, but they really are placing some restrictions on us and some changes that also may affect landlords with their ability to increase. So let's look at it. As of the 1st of May, the only way a landlord can increase the rent, the only way, there is no other way, will be by Section 13 notice. Currently in the original world, in the existing world, we can negotiate a rent increase with a tenant. We can verbally agree an increase with the tenant. We can have a clause within our tenancy agreement that automatically increases the rent. In the new world, that is not going to be the case. The only way we can increase rents is by using a Section 13 notice. And the notice period that we need to give to tenants have been increased from 1 month's notice to 2. Now, tenants can challenge this via tribunal, which they currently can as well. So that part has not changed. What has changed, and is quite fundamental if you think about it, is that in the current world, if we serve a Section 13 notice for the rent to start on the 1st of April, let's use that as an example, and 8 months later we get a decision whereby the tribunal have said, yes, we agree with you, it is a fair rent, the increase will be backdated to the original start date, so the 1st of April, which was the date that we were enforcing it. In the new world, it will not be backdated, and it will only become enforceable from the determination of the tribunal date. Now, what does this mean in layman's terms? Well, Dawn, what this means to me is that what tenants can do is delay the rent increase by several months by just taking it to tribunal. And there is talk, and it hasn't been confirmed or denied, but there is actually talk, and I really hope this happens, that there will be a charge for the tenants of around £47 for them to make that application. But at the moment, that is not confirmed. Currently, it states there will be no fee for the tenant, and therefore my concern is that tribunals are going to get overloaded with tenants that just want to delay that rent increase. What I would recommend, and what we will definitely be doing as agents, I know Vanessa, me and you have talked about this, is we're going to try and be savvy with getting these tenants to agree to the rent increase before notice has been served, so that we're being proactive in our approach to mutually agreeing a rent increase, but formally agreeing, finalising that with Section 13 notices. Hopefully that way, by, you know, keeping good lines of communication, good lines of communication and good understanding with the tenant, the likelihood is that they will not apply to tribunal once that Section 13 notice lands, because they're expecting it. But it's something landlords need to be very, very mindful of. And any rent review clauses that are in existing tenancies will automatically become invalid as of the 1st of May. So whether they're in there or not, they're no longer valid. Now, there is a transition period for any Section 13 notices that are in existence, all right, that are already out there. So any that have been issued before the 1st of May will remain valid as long as the notice was valid when served. And there is no transitional end date to this. As long as it's in and it's been served, they will remain valid under the old terms with backdated rent amount, 1 month's notice required. So that is some good news. So if they're already out there in existence, because the timing surrounding tribunal decisions are quite long. I mean, I had one landlord serve the notice, tribunal was applied for in April, and he didn't get the determination until October, some 6 months after the original date. So something for landlords to be mindful of here. I'm going to whiz through the last sections, Vanessa, and then stay open for questions and answers that you have, if that's okay with you.
Yeah.
Because these points are a little bit less heavy and a little bit lighter, but still really, really important because they do come with some hefty penalties if we fell foul of them. So we should all be already aware that in the private rented sector, we all have to operate under Discrimination and the Equality Act of 2010, which is very clear that you cannot discriminate against race, sexual orientation, sex, gender, and so forth. That is a law in itself. But the Renters' Rights Act has introduced a couple more things under rental discrimination that don't fall under the Equality Act and therefore only fall under the Renters' Rights Act. But quite simply, landlords can no longer blanket ban children and or housing benefits. You are not allowed to refuse viewings to these type of people. You have to consider them as an individual applicant in their own right. Now, insurance may restrict. For example, it may state that children are not allowed or housing benefit is not allowed. But as soon as that insurance renews after the 1st of May, those restrictions will no longer be a reason why landlords can decline. Mortgage restrictions are no longer allowed. It's been common in the buy-to-let market that mortgage restrictions do not allow housing benefit. They only want working tenants. That is no longer a reason because mortgage restrictions can no longer be used. Landlords must not auto-reject applicants that fall under children and or housing benefit. Every decision that is made needs to be assessed on its own individual merit based on affordability and suitability for the property. This must be the reason the decision was met, and of course, evidence must be required. So from a landlord's point of view, if you have multiple applications, you need to be able to determine that you've dealt with them all in the same merit, and affordability and suitability was the reason why you made the decision and not the fact that that person was on housing benefit. Now, 90% of the time, housing benefit tenants will not meet your affordability criteria, and you are therefore allowed to decline them on the basis that they don't meet affordability criteria, just like you are a working applicant. You just need to be very careful. As you can see, their new favourite number is number 7 and number 40, and this comes with a up to £7,000 penalty. Very similar thing with pets, okay? Landlords must now reasonably consider pets in properties. In order for the request to be considered, the tenant must make the request in writing. Now, a landlord must respond in writing within 28 days, given their decision and the reason for the decision. So what I would suggest is that you have a process for pet requests. We've actually created a pet application form, whereby the tenant has to fill in a full pet application form, giving all of the details about the pet, so that the landlord has all of the information that it needs. Things like how long will the pet be left at home? How often will the pet be left alone? All of these types of questions. Create yourselves a process for request. Create yourselves a process for response, and make sure that if you are declining, that it falls under the reasonable decline category. One of the things I can say that they have said will not be a reasonable reason for decline is that the landlord is allergic to pets, cats, dogs, or so forth. And the reason why they've been very stipulative about that is because what they're saying is the landlord doesn't live in the property, it's not their home, and therefore doesn't have an effect. But what would fall under reasonable reason for decline is if somebody wants a dog in a flat, for example, with no outside space. If somebody wants a husky in a 1-bedroom Mews style house that does have a garden, but the property is really very small. But requests for things like hamsters, lizards, things that are not going to cause problems or are size dependent, we need to be very mindful. And then finally, with today's section, one of my biggest concerns and one of the things that we need to be very, very mindful of is something called rent repayment orders. As letting agents, we talk about this all the time, and we wish that councils and government and law did much more enforcement in our private rented sector. Because if they did, it would make it far more fair. And with all of the changes in legislation, really what they're focusing on is those rogue landlords, those rogue agents, those bad people. And it's having an effect, of course, on all of the good landlords and the landlords that are compliant and following the law. But this alone really will make a difference in the new world, because a rent repayment order basically gives the tenant the right to financially benefit should a landlord fall foul of a multiple array of things under the Renters' Rights Act. Now, a tenant can make an application in the new world for up to 24 months of rent to be repaid to them, should a landlord fall foul of one of the offences. And they also have up to a 24-month period after the offence that took place to make that application. So landlords could be faced with tenants that have long left them, but they were in breach of something during that tenancy, and the tenant comes out of the woodwork and claims back up to 24 months rent repaid. Now, one of the examples I'll give you here actually happened to a colleague of mine. She has a daughter that's at uni in Liverpool, and she is renting a Liverpool city centre apartment, paying £1,000 a month. Property is riddled with damp and mould. She reached out to me in the job that I do and said, what can I do? I said, well, get the council in to come out and enforce that the landlord carries out the repairs. Upon them calling the council out, it was very quickly highlighted that that property fell under a selectively licensable area, and the landlord did not have a selective license. And selective licensing in that area has been enforced for probably the last 2 to 3 years. In the current world, the tenant was able to make an application for 12 months rent back. That's £12,000 rent returned to them, financially going in their pocket. In the new world, that could have been £24,000. There's a financial benefit to tenants personally, where landlords are getting it wrong. And I think landlords need to be very, very mindful that this exists, because this could become very, very costly to them. So to summarise my opinion of the Renters' Rights Act, and to summarise it in my words and my terms, the biggest risk to landlords under the Renters' Rights Act is no longer bad tenants, it's actually bad paperwork. Because you could have bad tenants, but if you've got bad paperwork, those bad tenants become a bigger problem because you're not able to get rid of them. Landlords haven't lost their rights, but they have lost the margin for error. We are trying to exit rogue landlords and landlords that are not doing things properly and compliantly, so they have lost their margin for error. I truly believe that this is no longer about owning a rental property. It's actually about operating a fully compliant rental business, whether you own one property or multiple. It is no longer just about owning a rental property accidentally and becoming a landlord. In the new system, possession will depend less on what actually happened and more about what you can prove. And actually that stands for everything in the new world. It's going to depend much less on what happened and more about what we can prove. And my closing statement is the landlords who stay compliant will stay profitable. And the ones who don't, they will become the examples that I mentioned in the case law that will be coming our way in the next year or so. So Vanessa, thank you for having me. Hope you guys all found that useful. As promised, I'm happy to stick around for any questions that may be had.
Amazing. Thank you so much, Dawn. That was super, super informative. Lots of clapping. Those are claps, hands and thumbs up there. Very super duper clear, super informative. There are a few, I'm conscious of time, so we'll probably spend, and we've literally kept everybody bar a handful of people on the call, which shows how informative and how clear the information you delivered was. So we'll just take a few questions for the last 3 to 5 minutes so that these landlords can get their opinions heard or their questions answered. So we have a landlord who says, this is more of a statement than a question, all this is going to discourage landlords. The stock market is much better. I've had landlords say that to me all along. Now we go to crypto, or we do this, or we do that. But you know, all investments come with a risk. And I think, like you said in your closing statement, it's now going to be about landlords being forced to be professional, operating a landlord business, as opposed to just saying, I have a property and, you know, I wing it. That's the difference.
I think the world's also very volatile at the moment. Look at the fact that we're at war again, you know, that the stock market can easily just be affected as much as this. I mean, the one good thing about property is this, you know, bricks and mortar don't lie. Your investment is going to remain bricks and mortar. 90% of the time, your asset is always going to grow.
Another landlord says, this is an interesting, this is more for us as agents. How will agents' management fees and letting fees be affected and billed going forward with the new APTs, the new Assured Periodic Tenancies?
Well, you know what I'm going to say, Vanessa, because this is what I say to all of my landlords. Well, our workload is going to increase by 20 to 40%. That is the workload increase that letting agents are going to face. So don't be alarmed if letting agents that you use up and down the UK are looking and revisiting the fees that they're charging, and that is going to go up in an upward trajectory. Because let me ask you the question, and this is the question I always ask landlords: would you take on all of this additional workload and not amend your fee? But I think in terms of the question that he's asking there, I think it's more southern based queries, because I know down south that the charging structure for letting agents is quite different. But we charge monthly management fees on a monthly basis that the tenant is in situ. We will continue to do the same up north, but I don't know how it will affect you guys more southern regions.
I think just last thing. Oh, this landlord here is asking about the current status of selective licensing in Luton. But I think that's a whole separate subject. I'm happy to send you an update email or ping you some information on that. I think today we want to stay focused on the Renters' Rights Act. Like I said at the top of the call, VA, there is a risk assessment that we're doing for landlords. If we will put up the QR code again, you can zap the QR code and you can actually check the health status of your current tenancies. That will give you an indication of how you sit with your paperwork at the moment. And if you'd like to book a call with either myself or a member of my team, again, we're here for you to jump on a quick call and help talk through any questions and concerns that you have and sort of guide you through the next steps over the next coming weeks. So the link is just in the chat. So please do feel free to click the link. It takes literally 10-20 seconds to complete it, and then we will book a call and we'll talk to you about your specific concerns or property questions. Dawn, do you have anything you want to add?
I just have one final thing to say, because I can see the chat here, guys, and thank you for all the you know, the waves and the hands up and everything, and for all of your questions today, because it does really make my job much easier to have interaction. But I can see the comment there that Airbnb might be the way to go. I think what we need to do is really be very mindful of this, because short let tenancies are also under the radar of government, and not because those that are genuine Airbnbs, genuine holiday lets, genuine you know, short-term accommodation, but again because our sector is one of those sectors where we try and find loopholes. So that is also under scrutiny at the moment, and there's some quite strict rules coming into force with regards to short lets as well. So I just thought it interesting for me to say, like, there will be some changes coming in that area as well. So it's not always the best solution.
Thank you, Dawn. I think we will close there. Thank you everybody for joining. It's been a pleasure to have you. It's been so great to see so many landlords online. Like I said, I'm around. The link is in the chat. We'll also send out the link via email to everybody who's registered, together with the risk assessment link, so that if you hadn't had time to zap the QR code, I think it's really important that you do take advantage of the risk assessment. It's a quick, I think it takes 30 to 60 seconds, and it will give you a rating as to how healthy your current tenancies are looking, because you do not want to fall foul for the small little things that you could easily correct now. So please do take advantage of the health check so that you can see where you stand with your tenancies. And of course, we will be back probably give us another 4 to 6 months, and we'll probably be back. It'd be great if I could just prize Dawn again, and we'll come back and we will tell you how things have played out. And obviously there'll be more information released, and we'll be able to help educate and give you the information and knowledge to help us all move forward as landlords once we know more, and as the Renters Act starts to play out in real time. I think that'll be a good one.
Absolutely.
Maybe in 6 to 9 months' time. So thank you, everybody. Wishing you a good evening. Thank you for joining, and wish you a good night.
Thank you.
Thank you.